But that interpretation can hinder access to property by disadvantaged persons.
Now, I mentioned the issue of identifying bottlenecks. We have a number of legal professional bodies, and I've said to them in my speeches to their AGMs, why don't you create a legal fund? And I give the example of Thurgood Marshall, Justice Thurgood Marshall in the US, when he was a lawyer of the NAACP. He realized the NAACP has no money, but there are a lot of social transformative cases that he wants to take that can be funded. And they allowed him to create a fund, a legal fund, which would fund this litigation. And he was successful. So I use that example, and I want to use it in answer to you partly to say we've got organizations in this country that can establish those funds and that can interact with societal formations or with communities. I chair CAUSA, which is a grassroots access to justice level, and the needs for legal services is very big. So through those funds, I think critical areas like those you've mentioned can be funded from deep pockets to make sure that the Constitutional Court is actually challenged to develop the Constitution in the way the Constitution was conceived. Let me stop it there.
Yes, thank you. I mean, suppose primarily what judges do is to interpret the statutes or the common law or the Constitution, but in a given case. But that interpretation can hinder access to property by disadvantaged persons. But then the only way the judges can do that is to be conscious every time they interpret the Constitution what they're trying to do. In other words, are they trying to rupture the existing economic relationships? Or are they trying to preserve them even unconsciously? And that is where I think I always have a difficulty, is that you get a judgment that is worded in apparently neutral terms, but its impact is radical in preventing black people from accessing property. Because at the time the case was argued, just no one thought about the implications, because everyone thought, let's apply the rules. But they have forgotten that those rules developed in a socio-economic context of marginalization. So I just want your view on that issue of that sort of intellectual awareness that the law operates in a social context, but that context is to be sort of broken by this new constitution.
That is a function of conscientizing the judiciary. One of the judges we have appointed in Gauteng is extremely radical. But if you listen...
I don't want to know the name.
But he's radical in a positive way.
Oh, I see.
Because he's challenging us, who've been there for 20 odd years, to say, you've been here, and this is how you've been interpreting the law. You've sold out. That's the language he's used.
What do you say to that when they say you've sold out?
Well, selling out is too strong to put. But Commissioner Ngcukaitobi, you know, we have educational problems where judges are exposed to training if they're going to sit as equality court judges. I want to think that training can be embedded deeply for judges to actually understand what is it that they are going to be dealing with on the equality law front, not just process. It goes deeper. So social awareness, you know, and equality awareness, the past will come. I mean, that judge that I mentioned said to me when I said, but you didn't put your name forward to be trained on equality court cases. He said, no, a white man won't tell me what apartheid did to me. That's a very profound answer. So I think we need to embed more of these training sessions that actually challenge us and actually enables new incomers to the bench to actually understand. Because generationally, maybe we have sold out in being conservative and in interpreting things in one way, right? So I think my answer is that there needs to be this continuing engagement. And, you know, when I interact with colleagues in the continent, because some of them are more conservative than us, I'm sure you're aware of that, and ask, but you guys, you unshackled yourself from colonialism years before we did, but we've advanced further than you. Why? You know? So it is this conservative legal culture that I mentioned that's shackling us. And once we admit it as the judiciary, then we are well on our way to interpreting the Constitution in the right direction.
And then just lastly, JP, on the issue that you've dealt with, I think you gave the judgment in the competition court, although it was about jurisdiction in the Group 5 case, where you were in the minority. Regrettably, you agreed with me, but you were in the minority, so it didn't really help my client. But there's something important about that, which is you're talking about a conservative legal culture, and competition law is a particular area where this conservative legal culture plays itself out, and where the Constitution is playing a catch-up game, and there is no infusement of constitutional values within the interpretation of that statute called the Competition Act of 1998. And I want to single this out because if you compare it, for instance, with labor law, the judges are quite happy to infuse labor law with constitutional values. Or you compare it with land law, they're quite happy to infuse land law with constitutional values. But they are extremely reluctant to infuse competition law with constitutional values. Can you just articulate that for us and explain what your approach will be to that particular statute? And I ask this deliberately because you've got experience in it. You've written a judgment on it. You've had the debates on both sides.
I think, let me repeat, it's the conservative legal culture. And before I answer that one, there's another one that you're not mentioning. It's the Standard Bank case. As the leadership of the bench, we realized that the big players with deep pockets were actually using the current legal processes to actually disable vulnerable people. Because Pretoria has jurisdiction in Soweto, they could issue process against a Soweto bondholder in Pretoria. For that person to go to Pretoria, he or she may need to catch 3 or 4 taxis to get to Pretoria. That's one. 2, we say, but this claim is in the jurisdiction of the magistrates court. Why not issue this thing in the Soweto Magistrates Court, where this litigant is located? And we issued a Rule 16 notice and invited people because we knew what we were trying to solve. But legal culture trumped us because the SCA said, no, you've got inherent jurisdiction. And inherent jurisdiction is an incident of the common law. It says the High Court has inherent jurisdiction. But we understand that. We've got inherent jurisdiction, but we say, despite that jurisdiction, let's understand the realities that we have now, that this inherent jurisdiction is leading to injustices. The SCA told us to get lost, and the Constitutional Court told us to get lost. So in Group 5, it's the same thing. Co-conspirators of Group 5 went and pleaded guilty and got fines on direct competition law issues. And Group 5 decided to say, no, the High Court has jurisdiction, simply because they want to bypass the tribunal. which is the body that is properly capacitated to deal with competition law issues. I went out on a limb on my own because I believe that I was correct. And you can talk to the chairperson or the JP of the CAC now. The effect of the majority of the Group 5 decision is that the tribunal is now routinely bypassed.